Today, we're going to jump into a really fascinating piece of legal history, one that totally changed the game for how words, reputation, and the media all interact in the UK. We're talking about the Defamation Act of 1952, a law that was a huge modernizing force for its time. But let's start with a hypothetical. What if you publish something that damages someone's reputation, but you had absolutely no intention of doing it? It was a complete and honest mistake. What do you think should happen? Just hang on to that thought, because the answer is one of the coolest things about the 1952 Act. All right, so here's how we're going to break this down. First, we'll look at why the old law was such a mess. Then, we'll see how the new act came in to fix things. We'll talk about how it handled new tech, like radio, check out some new legal shields it created, and finally, see where it all stands today. So let's rewind the clock to before 1952. The law around defamation wasn't really a single law at all. It was this kind of tangled web of old court decisions. It was full of what lawyers at the time called technical difficulties and perceived injustices. Basically, it was confusing, clunky, and just not built for the 20th century. And a huge part of the problem was this classic division between libel and slander. You see, libel was for permanent stuff, like something written down in a book or newspaper. Slander was for temporary things, like spoken words. Now, why does that matter? Well, to sue for slander, you usually had to prove you suffered a specific financial loss, what the law calls special damage. This made it way, way harder to win a slander case, and that difference had massive implications. And this is where our hero enters the scene, the Defamation Act of 1952. This was the big legislative fix that was designed to cut through all that old confusion and bring some much-needed common sense and fairness to the whole system. You know, at its heart, the Act's mission was pretty straightforward. It was all about modernizing. It wasn't trying to tear everything down and start from scratch. It was more like a targeted upgrade, fixing the biggest, most obvious problems to make the law work better in the real world. Now let's dig into one of the first major reforms. The 20th century, of course, brought all this new technology, and the law was seriously struggling to keep up. I'm talking, of course, about the rise of the radio. This new tech created a massive legal headache. I mean, think about it. Words on the radio are spoken, right? So that sounds like slander, but they can also reach millions of people instantly and be recorded, which feels a lot more permanent, more like libel. The courts were basically stumped, going back and forth on it. So the 1952 Act just sliced right through that knot. It made a clear ruling. For legal purposes, broadcasting is to be treated as libel. And this was a huge deal. All of a sudden, it became way easier to sue a broadcaster for defamation, because with libel, you didn't need to prove you lost a specific amount of money. This dramatically shifted the power balance between individuals and the powerful new media company. Okay, but the Act wasn't just about making it easier to sue. It was also about fairness. It introduced some really important new defenses and protections that changed how these cases were argued. We're going to walk through 4 of the big ones. A new rule for slander related to your job, this clever new idea called the offer of amends, a more realistic way to prove something was true, and finally, a little boost for cases of malicious falsehood. First up, the Act said, look, spoken words can absolutely wreck someone's career, so it made a new rule. If someone slandered you in a way that directly related to your profession or business, you could sue them without having to prove you lost a specific client or contract. It put a much stronger shield around your professional reputation. And here it is, the answer to that question from the beginning. The Act created this brilliant new defense called the offer of amends. Basically, if a newspaper or publisher could prove they defamed someone completely by accident, they could issue a public correction and apology. If the other person accepted, that was it. Case closed. It was a brand new common sense off-ramp to avoid a massive court fight over an honest mistake. The Act also made proving the truth, what lawyers call justification, a bit more realistic. Before, you pretty much had to prove every single tiny detail of what you said was 100% correct. After 1952, the rule became more practical. As long as you could prove the main damaging parts of your statement were true, you could still win, even if you got a minor detail wrong, as long as that error didn't make things any worse for the person's reputation. And finally, just to cover all the bases, the Act also strengthened protections against other kinds of lies, like someone deliberately spreading falsehoods about your business's properties or products just to hurt you financially. It was just another way the law was trying to catch up to real-world scenarios.
So after all that, where does this nearly 75-year-old law fit in today? Let's take a step back and look at the bigger picture to really get a sense of its impact over the long haul.
You can really think of the 1952 Act as a crucial bridge. It took the UK from that old, messy common law system and carried it for over 60 years, paving the way for the next great legal overhaul, which came in 2013.
But here's the key takeaway for today. While the 1952 Act is historically super important, it's not really the main player anymore. For the most part, it's been superseded. Defamation law in the UK now is really all about a much more recent law, the Defamation Act of 2013.
And that 2013 Act brought its own game changer to the table, the concept of serious harm. This raised the bar way higher. Now, it's not enough to just show that a statement was defamatory. You have to prove it caused or was likely to cause serious harm to your reputation. It shows just how much the law keeps shifting and evolving.
And that really brings us to the big question, doesn't it? From the age of radio in 1952 to the age of social media, AI, and deepfakes today, the way we communicate is constantly in flux. The law is always playing catch-up. So the question for all of us is, what's next? In a world of algorithms and instant global communication, how should the law that governs our words change with it? Now that is something to think about.